By way of introduction, I want to say a few words about Justice Scalia, who was a member of our law faculty from 1967 to 1974. He taught courses in, among other things, comparative law, conflict of law, and contracts. After serving as Assistant Attorney General in the Office of Legal Counsel at the United States Department of Justice, Scalia was nominated by President Reagan to the D.C. Circuit and then to the Supreme Court in 1986, where he served for 30 years. Over those years, Justice Scalia was a good friend to the University of Virginia. In addition to hiring many of our distinguished graduates as law clerks, he took judicial notice of the singularity of our institution in United States against Virginia, a case which many of you are familiar with, or if you're one else, will be familiar with. That's the case involving VMI. The Supreme Court erred in referring to the Charlottesville campus of the University of Virginia. In footnote 4 of his dissenting opinion, a note that deserves as much fame among Virginia students as that other footnote 4, Justice Scalia wrote, quote, "The court must be forgiven by Virginians for quoting a reference to the Charlottesville campus of the University of Virginia. The University of Virginia occupies the portion of Charlottesville known not as the campus, but as the grounds. More importantly, even if it were a campus, there would be no need to specify the Charlottesville campus, as one might refer to the Bloomington or Indianapolis campus of Indiana University. Unlike university systems with which the court is perhaps more familiar, such as those in New York, Illinois, and California, there is only one University of Virginia." I'm fairly certain that those are the kindest words ever written about the University of Virginia in a Supreme Court opinion, and they probably will be until one of you ascends to the bench, so hurry up. It's our pleasure to have this panel on Justice Scalia and his legacy at the court and about the aftermath of his passing, both on the court's docket and on the current vacancy at the Supreme Court. Our panel today will discuss these three questions. First, what effect will Justice Scalia's passing have on the Supreme Court's current term? This term, the court is considering cases involving abortion, affirmative action, religious liberty, voting rights, compelled support for public sector unions, and numerous other issues. What will happen to those cases? A second question is, what are the procedures and politics of selecting a nominee to replace Justice Scalia? Senate Republicans have declared that they will not consent to any nomination put forward by President Obama. What are the consequences of that decision for future judicial nominations is among one of many questions raised in our current political circumstances. And third, what is Justice Scalia's legacy? Will his writings on originalism, textualism, and the rule of law have a lasting effect on our legal culture, or will they, as some have already predicted, fade as the composition of the court changes over time? With that, my primary job here is as timekeeper, and I intend to serve in that capacity, and I will turn over to our panelists those questions. So we'll begin with Fred Schauer, and then John Harrison, and then Dahlia Lithwick.
Thank you very much, and thank you to the organizers for creating this event, and to all of you for coming. In terms of the three questions that have just been listed, I want to focus on the third, the legacy, recognizing that legacies are not forever, and when we talk about a legacy, we are talking at best about something that will last into the intermediate term and not long term. So let me just briefly mention four different items that are part of, in my view, Justice Scalia's intermediate term legacy. First is in the area of free speech and free press. Justice Scalia was one of the leaders of what we might call the shifting valence of free speech, free press, First Amendment kinds of considerations. That is, back in the 1950s, when one of the big free speech issues was what to do about communists, socialists, and various other ists, and in the 1960s, when the big free speech issues mostly surrounded Vietnam protests and civil rights demonstrations, during those periods and into some part of the 1970s, broadly and simplistically speaking, free speech was the province of the political left. Most of the arguments made for strong free speech protection came from the left of center. Most of the opposition came from the right of center. That has changed dramatically, whether we think about issues of commercial speech or campaign finance or some number of others. The political valence, the political direction of most but not all free speech arguments has changed quite dramatically. Justice Scalia, perhaps most angrily in his opinions in the abortion picketing cases, has been one of the leaders, if not the only leader, or one of the leaders in this shifting political valence of free speech ideas. No longer do we think of the strongest free speech arguments as coming from the left. Justice Scalia, assisted by others, but he was clearly the leader, the first and the loudest in shifting how we think about free speech issues. Second, you all learn, I hope, as first-year law students about stare decisis, the obligations of what I like to call horizontal precedent, that is, the obligations of a court to follow the previous decisions of that court, not just a court above. Justice Scalia was probably the most prominent critic of the very idea of stare decisis in the Supreme Court. He articulately said, I recognize what stare decisis is. I understand the arguments for stare decisis. I don't believe in them. Occasionally, he said things like this in his opinions, mostly off the bench. His view was, I took an oath to support and uphold the Constitution. I did not take an oath to support and uphold my predecessors' misreadings of the Constitution. I'm not sure whether he put it in exactly those words, but pretty close. And occasionally, he would make exceptions from that view. In extreme cases of protectionism, he was willing to strike down state statutes under the Dormant Commerce Clause, even though we thought Dormant Commerce Clause doctrine was mistaken from the outset. But in general, he put on the agenda a genuine question about whether the Supreme Court is under any obligation at all to follow the decisions of previous courts. Third, as Micah mentioned in his introduction, Justice Scalia, in issues of both statutory interpretation and constitutional interpretation, has dramatically shifted the nature of the debate. It used to be a debate between so-called living constitutionalists and original intent people, of whom the most prominent in the 1960s and 70s was probably Raoul Berger. Original intent has, if not entirely, largely dropped out of these debates. The debates are no longer about original intent, but about original public meaning. What was the ordinary meaning of these terms, whether in Constitution or in a statute, at the time that they were adopted? That's a dramatic change. This is due almost entirely to Justice Scalia, his on-the-bench and off-the-bench writings, his on-the-bench opinions and off-the-bench writings, both about statutory interpretation and about constitutional interpretation. Whether it be the University of San Diego's Center for Originalism or a large number of books and law review articles, the entire nature of the debate against, or the entire nature of the position against so-called living constitutionalism has been shifted from original intent to original public meaning. That will last for some time. That's almost entirely Justice Scalia's doing. Finally, and perhaps less prominently, although perhaps more importantly in terms of actual litigation and actual cases, Justice Scalia has had a huge impact on actual criminal trials, including domestic violence cases, including child abuse cases, by virtue of his very vigorous and very robust defense of the Confrontation Clause of the Sixth Amendment. Whether it be his initial opinion in Crawford versus Washington or some number that have come after that. He took the Sixth Amendment Confrontation Clause very seriously. Large numbers of people who have no idea about the difference between original intent or an original meaning, or who could care less about stare decisis, who have little exposure to free speech, are nevertheless people who on a daily basis, whether as prosecutors, defense lawyers, or as defendants, deal with Crawford and the Confrontation Clause revolution. That will again possibly last for some time. Again, it is part of Justice Scalia's legacy. Thank you.
Thank you. I'm going to say a little bit about all three of those questions, primarily about the third. On the first point, I'll just say, now that the court has an even number of members, the question is, what will they do when they are evenly divided? And they have two options. When that happens, they can either proceed to decide the case by affirming the decision below by an evenly divided court, or they can not decide it and hold on to it until they have an odd number of justices. One thing I have not been able to determine, I've been in a couple of conversations about this with a number of people here who know something about how the Supreme Court operates. We had about 45 minutes on this yesterday afternoon. What happens if they are divided 4-4 on the question of what to do as between those two options? And if anyone knows the answer to that, please tell me, because we were not able to find it in any regular source. The second thing I'll say just a little bit about is the sort of what's going to go on with nomination and confirmation. And the short answer is it is entirely up to the president whom to nominate, and it is entirely up to the Senate what to do about that. And the current Senate has indicated that they are not even going to hold a hearing. My own guess, just from the standpoint of thinking about the politics of it, is that that is what they will do. But promises in Washington last as long as promises in Washington last. They are good until they are good until they are not good. What really matters, of course, is what happens in the elections this fall. And I would say that there are four possible configurations that could result: Democratic President, Democratic Senate, Democratic President, Republican Senate, Republican President, Republican Senate, and Republican President, Democratic Senate. But actually there are five, as one of our colleagues pointed out to me, because there's a Jefferson angle to everything. And in part because of what happened with the Jefferson-Burr electoral tie in 1800. The 20th Amendment provides that the new Senate comes into session on the 3rd of January, and the new president takes office on the 20th of January. That is so that if either the House or the Senate has to choose the president, as in 1800 and 1801, it will be done by the new Congress rather than the lame duck Congress. But the result is, another possible configuration is, in particular, if a Republican president is elected but the Democrats take control of the Senate. I don't think that's terribly likely, but anything can happen in American politics, especially this year. One possible configuration is a Democratic Senate and a lame duck Democratic president. And my guess would be that the president would make a nomination and the Senate would confirm the nominee. If that doesn't happen, as I say, it's the other four configurations. Two of those would be smooth sailing. That's the way it's been for the last 6 Supreme Court vacancies. The other two configurations would be, well, I was about to say Armageddon, but I've been to Armageddon. I worked on Supreme Court confirmations for a Republican Justice Department with Democratic Senates, and the next time will be whatever is a step up from Armageddon, because the stakes are, if anything, higher, and the parties are, if anything, more polarized, especially on issues related to the Supreme Court. So Armageddon plus is what we will see if the presidency and the Senate are in opposite hands. Now a little bit about Justice Scalia's lasting legacy. And the first point I want to make is that there will be one. It is not necessary that one be able to vote on the Supreme Court in order to have a major impact on American law. See, for example, Richard Posner, perhaps the single most influential American legal thinker in the last 50 years. Some of that comes from what he's done on the Seventh Circuit. Most of it comes from what he has done as an academic. He is not on the Supreme Court, and probably after his advocacy in favor of selling babies, he wasn't going to be. Nevertheless, Posner has been immensely influential because of the positions he took, the analysis he put forward, and perhaps most important, the issues he raised and the questions he put on the intellectual agenda of both the bench and the academy. And Justice Scalia has put extremely important issues on the agenda, and he's probably best known. Fred talked about a number of issues as to which Scalia has raised questions that people then have to grapple with. I think he's probably best known first at the micro level for his critique of legislative history, and then at the macro level for his advocacy in favor of meaning rather than intent. And I don't want to tell too many stories, but as to both of those, I was sort of an eyewitness. Then Judge Scalia first surfaced his critique of legislative history in a case called Hershey when he was on the D.C. Circuit in 1985, in which he quotes at length a colloquy on the Senate floor, the point of which is largely that Senator Bob Dole, then chairman of the Senate Finance Committee, had not in fact read the Finance Committee report that would become the authoritative legislative history for the statute in question. And Senator Armstrong was making that point to say, we're going to vote on the bill, not on the committee report. Well, I first heard Judge Scalia talk about that very exchange in Congress when I was clerking for Judge Bork, and he was talking to Judge Bork about it, and for some reason I was in the room. I now wish I could remember the circumstances under which that conversation took place, but I'm quite sure I was present for it for the following reason. Before clerking for Judge Bork, I had been for a couple of years a tax associate and had been taught that Senate Finance Committee reports were absolutely authoritative. And Judge Scalia shook me out of my dogmatic slumber, and I have never believed it since. Second, on the switch from original intent to original meaning, then Judge Scalia proposed that and that change of language in a speech he gave to an event I attended. Attorney General Meese held a day-long conference about economic liberties in the Constitution. The lunch speaker was Judge Scalia, and Judge Scalia talked about the problem with intent and the need to change to meaning, original intent to original meaning. So I saw that happen too. Beyond just telling stories, I want to say that with both of those criticisms, Judge and Justice Scalia raised fundamental questions that have occupied scholars and will continue to occupy scholars for some time because they are so basic. For example, one reason to switch from intent to meaning and one reason to be a skeptic of legislative history is because of doubt about the possibility of collective mental states. Is Congress an it or a they? This is something that Professor Schwartzman has done important work on recently. People are working on answering that question, and part of the answer, because of course it's being provided by academics, is yes and no. That is to say, it is very difficult, and these are the results, to bring Jefferson again in. Jefferson's friend, the Marquis de Condorcet, was the pioneer of this. It is very difficult to say that a collectivity, say a legislative body, can have a shared intent in the sense of having shared preferences as to outcomes. The entire problem of social choice functions, Condorcet and Arrow's theorem, demonstrate how difficult that is. So if legislative intentions are understood in those terms, and those are the terms of legislative intention that Justice Scalia primarily wanted to criticize, it is very difficult for there to be shared intentions. By contrast, it is much easier, and Professor Schwartzman knows more about this than I am, to say that a large number of people share a linguistic intent, share a mental state directed at some kind of linguistic or communicative object, a meaning. And of course, that's the sort of thing that Justice Scalia said did constitute the law. So in that respect, and there's a lot of very sophisticated work being done right now, the question Justice Scalia raised is extremely important. The second point he made, or a related point related to what he said, has to do with the idea of communicative content and its relationship to the law. Fred mentioned the Originalism Center at the University of San Diego. I was just out at their conference last weekend, And at a lot of conferences, all the really interesting conversations take place afterwards, after the papers are presented. And after one of the papers was presented, three of us, two I guess you would characterize as originalists and one you would characterize very much as not originalists, had a really interesting and quite abstruse, I understood parts of it, conversation about the question, what is the relationship between communicative content, if you think a text is the law, and legal content? Are they necessarily the same thing? And one possibility is that they are not quite the same thing, that there is some relationship between the two, that somehow meaning produces law but is not law. If that sounds like angels dancing on the head of a pin, to some extent it is. But it is a serious question at least to address. The answer may be it's not a real question, sometimes that's true. But if it is a real question, it's, as somebody has said to have written in a copy of the Bible, important if true. If that question is a genuine one, then having an answer to it is extremely important. So that's another topic on which Justice Scalia has raised and brought on the agenda some extremely profound issues that people will continue to grapple with, certainly for the next couple of decades. In the long run, who knows? In the long run, the sun will burn out. The last thing I'll say along those lines is that Justice Scalia's impact will be greatest insofar as it is cut loose from debates between right and left, and hence insofar as it is cut loose from his vote on the Supreme Court. There, it's liberals and conservatives, but these questions about collective mental states, questions about exactly what legal questions are, don't have that valence or have it only a little bit. They are, in the currently fashionable word, orthogonal to ordinary right-left debates. And so the last thing, I know you didn't come here for a reading assignment, but the last thing I'll say is to suggest if you want to know more about Justice Scalia as a thinker and in particular as a constitutional interpreter, and get some really interesting context for his thinking, there's a case you should read. It's Ullman against Evans. It's 750 F. 2nd 970, the D.C. Circuit in 1984. You can tell that it is cut loose from political valence because then Judge Scalia on the D.C. Circuit sided as a matter of outcome with a communist. And that's not a metaphor, I mean a communist. And had a quite sharp and fascinating interchange about constitutional interpretation, the difference between, in some sense, text and intent, the levels of abstraction at which constitutions are to be understood, whether constitutions should be understood textually or in terms of their purpose, with another judge who was a pretty serious student of constitutional interpretation. And between them, they really framed the issues in a quite enlightening fashion. So again, you should read Ullman against Evans, 750 F. 2nd 970.
Well, I want to start by thanking the organizers and thanking Micah for including me. I'm going to just play a journalist, which is what I do best, and talk. I'm going to amplify, I think, on all 3 points. And I just want to say I've been thinking a lot about the effect on this term, the question about this term, because, you know, in the first 2-3 days after Justice Scalia died, everybody said, you know, all these unbelievable, right? This was going to be the term of our lifetimes, and we forget that, but this was going to be the term that we all told our grandchildren about, except maybe now it's not. But, you know, we were gonna decide affirmative action. We were gonna decide abortion. We were gonna do Hobby Lobby 2.0. Then we were gonna do voting rights. Oh, and then we were gonna do Obama's immigration reform. So this might have been a hugely consequential term. And the first take, I think, out the chute, everybody said, well, now we're just going to have a bunch of 4-4, angry 4-4s, and there's going to be, you know, confusion and a patchwork of different laws in different jurisdictions, and nobody's going to know what the law is. The more I think about it, the more I think the court probably won't let that happen. I think that John Roberts is very astute. I think that the last time the court was shorthanded in the transition between Sandra Day O'Connor and Alito, the court was very, very careful to not look like it was imploding, and we saw a lot of very narrow decisions in that time. We saw a lot of jurisdictional decisions. There are ways for the court to not in June being a front page issue, where it looks as though the court is an angry 4-4 court. So boy, America, you better get out and vote about the U.S. Supreme Court. That's John Roberts' nightmare. He was at pains to say 2 weeks ago, long before any of this started, we are not Republicans and Democrats. Do not think of us as a political entity. What he's saying is very, very clearly, and he said this for a long time, Ted Cruz stopped talking about me because I'm not the issue this election. And I really do think that there are ways, whether the court decides to hold over cases, it's tricky to hold over cases if you're not going to have a court the next year. So that would be the obvious thing, is to just re-argue everything next term. I don't think we're going to have anybody seated in October, so holding things over doesn't necessarily solve the problem. But I think by some combination of having re-argument in some cases and having tiny jurisdictional decisions, we may not see an explosively angry term at the end of this term. I think all of the justices want absolutely nothing to do with being an election year issue. And I think the other thing that I just find really interesting is that one of the consequences for this term and going forward is that if you look at the number of cases that were fast-tracked to the court this term, whether it was Friedrichs, whether it was Evenwell, whether it was the immigration appeal or the Clean Air Act, these were not cases that got to the Supreme Court by way of normal sequential procedures. That whole machine is kind of collapsed. The idea that we can get to the court really, really quickly has, I think, gone away. And so it's just going to be really interesting to see. This is kind of the last term that I think we're going to have for a while, depending on who's seated, where that fast track get this in front of the justices quickly because Sam Alito really wants to decide X. I think that has vaporized, and I find that a fascinating proposition. In terms of what's going to happen next, I just have to agree. Anybody who tells you they know what's going to happen next is lying. We don't know what's going to happen next. What we do know is that President Obama has said he will put up a name. I suspect he will do that in the next few days. I think he's going to put up somebody. I do not think he's going to put up the Republican governor of Nevada. But I do think he's going to put up someone who is mainstream in his view, and I think very likely he will put up somebody who got Senate confirmation by a 98 or 97-0 margin by all the senators who are now saying they can't vote. So I think we are very likely to see somebody who has just been confirmed. I think that for folks who are hoping that Obama is going to just pull the ripcord and nominate Pam Karlan or Brian Stevenson, no, that's not going to happen. And even if Obama had the Senate and had the possibility of confirmation hearings, I think by temperament, he is not a person who was going to put up the liberal version of Antonin Scalia. And while, all sorts of people can write that piece over and over again in the Huffington Post, it doesn't make it happen. Obama's been really, really clear that what he, and he said this time and again, and we should probably listen to him. I have a lot of respect for Justice Marshall. I have a lot of respect for Justice Brennan. The time for that kind of justice is over. And I will, he believes that elections matter. He believes that it is not appropriate for there to be liberal activists on the court. And I don't think even in his dream scenario, he would put someone up. He's been very clear yesterday in his statement that you may have read on SCOTUS blog that the things that he values are people who are, clear scholars and deeply knowledgeable about the law. And he says over and over again, he said this when he tapped Sotomayor, he said this when he tapped Kagan, what he really values is people who have this quality of empathy, the ability to get out of the dusty law books. He always says that with such contempt for a con law professor. He loves dusty law books, but he always says, he wants somebody who can walk in other people's shoes, that what matters to him is somebody who's had a lived experience that is fundamentally different from the lived experiences of the other justices who all have remarkably similar lived experiences. If you look at where they were born, where they went to law school, their job descriptions coming into the court. And he says, although we'll see, that it's terribly important to him to put up somebody whose life looks different from that. And I think it's ironic that that was Justice Scalia's critique of the court in his Obergefell dissent, right? We all were like hydroponically raised underground to be on this court, and we've got to branch out, says Scalia. We'll see if Barack Obama could name someone like that, and even if he could, I think there will be no hearings until after the election. So I guess the question is, given that we're in a situation right now where we have complete and total gridlock, we have a president who wants to nominate someone and a Senate Majority Leader and a Senate Judiciary Committee that are saying we simply, not only will we not vote, we won't have hearings or even meet this poor candidate if they're dragged into our office. I think there is this real question of, is it going to matter? And it's really interesting to me because it's not clear to me that Americans care all that much about the court. They historically have not. Historically, Republican voters care a lot more about the court. But I think that really the gamble is whether this becomes a political problem. And we know from the early polling that it's a political problem in some of the swing states. It's a problem for Kelly Ayotte. It's a problem for Ron Johnson that, to be perceived as this obstructionist. But I don't really know if this becomes a voting issue in November. So I think the last thing I would say is that, when you're looking at the list of the kind of people that Obama wants to put up, I think it is worth remembering that this really will be his legacy. He has been at pains to put up women because that was important to him. It was important to him to put up the first Latina justice, and he did that. And I don't think he's going to think casually about this. I think this is a seat that is going to matter tremendously to him. And the only other thing I would say is that this has become such a profoundly symbolic conflict. I think that the symbol of what Justice Scalia represents, I mean, I haven't seen a symbol like this, the death of a symbol like this, since Reagan. And I do think if you want to do the mind game of imagining that it was another conservative justice, I'm not sure that it would have taken on the sort of galactic drama that this has taken on. The last two things I want to say are in terms of Justice Scalia's legacy. I do think that we can talk a lot about the extent to which originalism has become the only game in town. And after Heller, we all sort of said, we're all originalists now, right? Even Breyer's an originalist now. This is insane. But I think it's really worth reflecting that if you count the noses of originalists left on the U.S. Supreme Court, there's one. And it's Clarence Thomas, and that the other conservative justices, certainly neither John Roberts nor Alito, hold themselves out as originalists. Kennedy holds himself out as a Kennedyist, I think. And that it's really, really interesting to me that, when we have these discussions about how originalism sort of has changed everything, that it's entirely possible that there's only one true originalist left on the Supreme Court. I do think that, and this goes to the point that it doesn't matter who's left on the Supreme Court, because where it mattered was in the academy. Scalia was always very, very clear that he was writing not for his colleagues, but for law students. And that is where I think the legacy really does become hugely consequential, in that, none of us who've gone to law school when Scalia is on the bench can say that we're not completely shaped by his interpretive approach and his style. And I think that's the difference. I think that the other place that Scalia's massive legacy lies is just in the way he chose to write for the public and not for the court. And that if you look at how in his wake, both the Chief Justice and Elena Kagan are at pains to write the way he wrote, to write in tweetable units, and to write in ways that move the needle in Congress and move the needle in public discourse. That is a Scalia legacy, and I think it's important. The last thing I would just say about him is this question of tone. As the last few years, as his tone became more and more inflammatory in his writing and on the bench, I think there was a real feeling, I guess it was voiced most pointedly by Erwin Chemerinsky at UC Irvine, that it was affecting the way he saw his students write. and talk to each other. And that there has been, I think, I don't want to call it a coarsening, I'm not exactly sure what to call it, but a willingness to speak much more sharply at the court that I think he did put his imprimatur on, right or wrong. And I do think that you see it in other opinions, you see it in other legal writing, and I do see it absolutely sort of filtering out into the world. And so one of the questions that I do often have is whether the tone shifts back in his absence. So I'll stop there, but I'm happy to take questions about any of this. Thank you.